Good morning. My name is Malcolm Niekirk. Welcome to Fretton's 5th coffee break briefing of 2023. A particular welcome to those of you who were able to attend our annual conference last month, and we will shortly start planning our 2024 conference. I'd like to give you another reminder, please, to try out the retention of title website tool I showed you a couple of months ago. Why not scribble down a quick note to yourself to have a look at it at the end of this morning's presentation. Today we're going to be talking about agreeing creditors' claims. I've actually decided to split this into two parts because having prepared the presentation, I could see that it was going to be far too rushed to try and deal with it all in just 30 minutes this morning. So we'll deal with part one of it today, and part two will follow on next month on the 10th of July. Now, both parts one and two, I'll be looking mostly at voluntary liquidations with a particular emphasis on CVLs rather than MVLs. And the reason for doing that really is because, of course, agreeing creditors' claims is something that's common to all insolvency procedures. And the rules for all of them are similar, but not quite the same. And I thought there was too much of a risk that this would simply descend into a detailed compare and contrast type of presentation, which I think would be fairly mind-numbing for all involved. So what we'll be doing is looking at agreeing creditors' claims in the particular context of CVLs, looking a little bit at a couple of the other corporate procedures, but really just looking at this as being a way of picking up the general principles for other procedures that you're involved in. These are the key topics that we're going to be trying to cover today. In part one, which is all I'm going to be looking at this morning, I'll be looking at how liquidation stops litigation and insolvency moratoriums generally, and then moving on to looking at valuing creditors' claims for voting purposes. So part one, which I'm covering this morning, is really the sort of initial stages of the appointment. Part two is then the later stages of the procedure, where you'd be looking at valuing the claims for dividends, dealing perhaps with contested claims, perhaps creditors' appeals as well, and I'll finish off part two by looking at disclaimers. But it's part one we're looking at this morning, stopping litigation and valuing for voting purposes, and the first part of those is stopping litigation. And this is really all about the insolvency moratorium, and every insolvency procedures have a moratorium of some sort. The detail is different in different procedures, and in fact it's the differences between the moratoriums that seem to be some of the biggest changes that you get, the biggest differences that you get between the different types of procedures. And not all types of litigation and not all types of enforcement are necessarily treated the same way in the moratorium. And I'll be looking at some of the detail that applies to voluntary liquidations. This is intended to be just a sort of graphical representation of how different procedures have a moratorium with different strength. So the sort of industrial strength moratorium is the one that applies to administrations and the new statutory moratorium procedure. It's rather weaker for compulsory liquidations, weaker still for CVLs, and weakest of all in the case of MVLs. And of course that makes sense because in an MVL you should be going to pay all of the creditors what is due to them in full anyway, so you don't routinely need anything to hold creditors at bay. Administrations are quite the opposite, and where you may well need something to hold creditors at bay. You'll have seen I haven't put CVAs on that particular slide, and that's because CVAs, being a flexible insolvency tool, you can pretty well write your own moratorium, and typically it tends to be very, very similar to the liquidation moratorium, somewhere between a compulsory liquidation and a CVL in terms of its strength, but you could have a stronger or a weaker moratorium according to what the requirements of the case are. I also found it useful when looking at the way that the moratorium works, the different types of enforcement, to cut claims 4 ways. And so we have this sort of 4-quadrant matrix. And the horizontal cut I've got here is between property rights, which are always in a privileged position as far as English law is concerned. Property rights being essentially secured creditors as against unsecured claims, which are generally treated quite differently by the moratoriums. And there's also a vertical cut here between pre-appointment claims and post-appointment debts. And in the case of a CVL, that distinction between pre-appointment and post-appointment debts is not so important. But in a procedure like administration, it can be quite important to see how the moratorium applies differently to pre-appointment debts to how it applies to post-appointment debts. And of course, what we mean by secured creditors, creditors with property rights, are of course the list of usual suspects: mortgage lenders, leasing companies with goods on HP or leases, creditors who have supplied on retention of title, and of course landlords. And the example of the post-appointment debts, for which the moratorium may be a little bit different, for secured creditors, of course, may include things like mortgage interest, the rental of goods on hire, the value of goods on retention of title that are used or sold on. And you can think, for example, if you were even in a liquidation where you had a closing down sale of a shop and you were selling the stock there, if there was goods in that shop that had been supplied on retention of title, you can see that the creditor would have quite different rights and a rather different interest than they would if they were simply an unsecured creditor. And similarly, rent for the premises is a post-appointment debt to a property holding creditor. And usually the right that the secured creditor, the property owner, has in each of those cases is the ability to limit their losses simply by taking back their property. In administrations, that of course is not always so because of the strength of the moratorium that you've got there. So that's the 4-way quadrant in terms of looking at the effect of the liquidation moratorium on creditors with property rights or without, and whether they've got pre or post appointment debts. And this slide here is quite an important one. There's 2 definite takeaway points for you on this. It's about the importance of the Rule 614 notice, or you may call it a Section 100 notice. But there are 2 important points about that in terms of the moratorium that you have got in a liquidation. First one is that the Rule 614 notice should refer to the proposed resolution to wind up the company. And I think it's probably true to say that every Rule 614 notice I've ever seen does refer to the proposed resolution to wind up, but it's not actually on the, I don't think it's on the list of required information in Rule 614 itself. And the second takeaway point is to make sure that that notice goes out not only to all of the creditors, but it also goes out to any enforcement agents, bailiffs, and so on, who may be acting for any of the creditors, to make sure that they receive that notice of the liquidation as well. Let's look at some of the detail now in terms of the rules that exist to stop litigation, to put a stay on creditors' claims. And in voluntary liquidations, there is actually no automatic stay on litigation at all. In practical terms, you'll find that most creditors who have brought debt collection action against a company that then goes into liquidation, they will normally just stop what they're doing, because they will be advised, most solicitors know enough to say, well, there is no point in carrying on with the company once it's in liquidation, getting a judgment, won't improve your position. So it's just good money after bad. And that's the most effective stay that you have on litigation in a voluntary liquidation. However, if you need a stay, you can very often get it. And there is an automatic stay on litigation in compulsory liquidations. That's in section 130. And it brings all current litigation to a halt, and it stops any new litigation. The court has actually got a discretion to backdate that automatic stay to the start of the petition, if it's useful to do so. And the right you have got in a voluntary liquidation is the right to ask the court for a direction that confers on you the powers of a compulsory liquidator. And that would include, if you asked for it, the stay on litigation that a compulsory liquidator has got. So effectively, section 112 does give the court a discretion to enforce a stay, to order a stay on litigation, if it's useful to do that. If it's a CVL that you're looking at, then I think the court is probably more likely to give an order staying litigation. If it's an MVL, the court is going to be a bit more circumspect about it and is going to want some pretty good reasons as to why you actually need to stay litigation in an MVL. So again, going back to the matrix, dividing between property rights and unsecured claims, even in a CVL, you're unlikely to get a stay which prevents a property owner from enforcing their property rights. You're much more likely to get a stay that prevents an unsecured creditor from continuing their litigation. So what are the situations in which perhaps a court may refuse to grant a stay on litigation? I can think of 4 that I've listed here. The first one is where the company in liquidation is perhaps only one of a number of defendants. And in a case like that, the claimant may know that they're not likely to get any sort of financial restitution from the company in liquidation, and they're not really interested in that. But it may be important to them to keep your company involved in the litigation because they want to have access to the company's records, formal disclosure of the company's records. So that might be one example. And in fact, I covered that particular issue in a previous coffee break briefing on zombie litigation, I called it. If you want to look at that one, it'll still be available on our website. The other one, which is closely related, is if there is a claim under the Third Parties Rights Against Insurers Act. And an example of this might well be if there was, let's say, an industrial injury, a personal injury claim, where the person bringing the claim contends that they were injured as a result of something that happened to them while they were at work. And the company will carry, or should carry, insurance against that. And this legislation, the Third Parties Rights Against Insurers Act, that actually gives the claimant a right to bring their claim directly against the insurance company if the company itself that they should be bringing the claim against has gone into liquidation. And if they get a judgment against the insurance company will pay them directly. And this means that the damages that they're entitled to don't get paid to you as liquidator, because if they were paid to you as liquidator, you would have to distribute them amongst all creditors with an equal standing. So it ring fences the payment of compensation to the person who has been injured. Another example of a case where the court may not stay litigation is if the court thinks that there's a dispute which is actually better resolved in court, and that could be a dispute about quantum or liability or both, or possibly even something else completely. But if the court thinks that the court is the best way to settle the dispute, they may decide to let the litigation continue. And the fourth one just repeating a theme that's already resonated this morning, is if it's a property owner looking to protect their property rights, such as a landlord forfeiting the lease, a mortgage lender repossessing, or a leasing company seeking a protection of a property order so that they can take back a big yellow machine and sell it. I'll look at some of the statutory detail now for voluntary liquidations in the Insolvency Act, and I will also mention the charge in favour of preferential creditors on distrained goods in the Insolvency Act, although that only applies to compulsory liquidations. Just in case you're thinking at the back of your mind, don't preferential creditors have some special rights in all of this? Well, yes, they do, but only in compulsory liquidations. So the statutory rules are really about the situation where a creditor has brought debt collection litigation before the company went into liquidation. They've got a judgment, they're trying to enforce the judgment, and then the shutters come down, a liquidator is appointed at some point after they've started to enforce their judgment. And at what point is the line drawn that stops them from being able to keep the enforcement that they've started? And the basic rule is that the judgment creditor has to have completed their enforcement before you are appointed as liquidator, or if it's an earlier date, the date that they had notice of the proposed resolution to wind up the company. Hence my comment earlier that you really ought to put that notice in your 614 notice. And so the crucial thing is, what do we mean by completing enforcement? Well, in the case of enforcement against goods, enforcement is completed once the goods have been sold. If it's a third-party debt order, it's when the creditor has actually received the attached debt from the bank, and if it's against land that the enforcement is being taken, there are three listed there. Seizure and appointing a receiver hardly ever happen, but making a charging order is quite a common one. And a charging order is made in two parts. There's a conditional charging order and a final charging order, and simply making the conditional charging order would be making a charging order, and that would be regarded as completing the enforcement. Now, suppose the judgment creditor has started but hasn't completed enforcement against goods. So they've actually seized the goods and they're planning to put them into an auction for sale, but they hadn't actually sold them by the time they get notice that the company was in liquidation or was calling an EGM to pass a winding up resolution. In this particular case, this is about the enforcement officer's rights, and their rights are affected by the date on which they actually got notice of the liquidation or the winding up resolution, which again goes back to the point I made earlier about making sure that the Rule 614 notice goes out to enforcement officers as well as directly to creditors. And if the goods haven't actually been sold by the time the enforcement officer gets notice of the liquidation, then they have to hand over the goods to you, or any money that they have received for the goods. So if the company has itself paid some money to them to delay selling the goods, they'd have to pass that to you. They do, however, have a charge on the goods and the money for their costs, so they are entitled to be paid for the work that they have done. And this whole rule is one that the court has a discretion to disapply if it's appropriate to do so. In a compulsory liquidation, a winding up petition itself makes attachment or distress, which of course is a non-court procedure, or execution of a judgment, the court procedures, all of those are void once the winding up petition is running. And those that effect of voiding any of those enforcement actions can be applied by the court in a voluntary liquidation. So that doesn't automatically apply, but if you've got a pending liquidation where there's an awful lot of potential enforcement action, then it might be worth going to court to get an order just to confirm that any enforcement action is going to be void from the start of the, well, from the point where the notice has gone out to creditors. And here's the page about the charge for the preferential creditors on goods that have been seized in distraint, or CRA. This applies only to compulsory liquidation, so I won't say any more about it at this stage. So that's the stopping litigation part of what I want to talk about this morning. I want to move on now to talk about valuing creditors' claims for voting purposes. And I think what creditors often don't realize is that their claim is likely to be valued several times over the history of the voluntary liquidation. So there'll be a value given on it in the statement of affairs. There will be a value in the proof of debt they submit for the decision procedure. Post-appointment, if there's any more decisions to be made, for example, approving your remuneration, there will be another valuation for voting purposes at that point for that decision. And then finally, when it comes to paying the dividend, they then have to formally prove their claim. And there are different rules applying for valuing their claim for voting purposes to those that apply to valuing it for proving it for a dividend. For voting purposes, the rules are in 1531 to 1533. To prove a debt for a dividend, it's part 14 of the rules, rule 14. And it is the convener or the chair of the decision procedure who makes the decision on whether to admit the claim or not, and for how much. And remember, in a CVL, that may well be the director rather than you for the decision on who is appointed as liquidator. The choices that you have to make if you're either deciding yourself whether to admit or advising a director on whether to admit, fairly straightforward. You've got the choice to admit the claim in full, and the court's guidance here is that you should admit the claim in full if it is plainly and obviously good. The second point is that you should reject it in full if it is plainly and obviously bad. You've got the choice of admitting part and rejecting part, of course. And there's actually quite a broad gap between the claims that are plainly and obviously good and the claims that are plainly and obviously bad. And if there is any question or doubt as to whether it falls into one of those categories, then what you're supposed to do is mark the claim as objected to. And that is effectively admitting it. The creditor can then vote on it, but there's just a note against the claim that says that there may be an appeal to court about the decision made on it. And remember that there are preconditions as to when a creditor can vote, and those include that they have to have delivered a proof within the time limits that apply, and if you think any supporting evidence is necessary, they have to have delivered that as well. And of course, if a proxy is being used to vote on, they have to have delivered the proxy also. Now, in terms of what value you should put on the claim, well, you start with the figure that is claimed in the proof. And if you admit that figure in full, that of course is the value for voting purposes. For debts that are fully secured, then of course you value those at nil. For debts that are partly secured, you value the unsecured part only. If the debt is unquantified, unliquidated, or unascertained, of course, is the phraseology, then you start with the assumption that the value of it is nil, which is different from how it is in the CVA, where you value it at £1. But in a voluntary liquidation, you would value it at nil if it is unquantified, unless you decide to put an estimated minimum value on it and admit it to vote. And of course, this is an area where you should act reasonably in deciding whether to put an estimated minimum value on it and what that value should be. Creditors, of course, have got the choice to vote on less than the admitted value if they wish to do so, and they can split the way that they vote. So part of their claim could be for the resolution, part could be against the resolution. Contingent claims are not expressly covered by the rules. So if you've got a contingent claim, one where you don't know whether it's going to be a good claim or not, you firstly have to decide whether to admit it or reject it in whole or part, or mark it as objected to. So that's essentially the decision on liability. Then, having decided whether you're going to admit part of it or all of it, you then have to assess whether it is unliquidated or unascertained. And that's very often going to be the case for contingent claims, is that they won't have a certain value to them. So you don't have to put a minimum value on it, but you should if it is reasonable to put a minimum value on it. And of course, creditors have got 21 days to appeal your decision if they are dissatisfied with the extent to which you have admitted their claim or your reasons for doing so. And their other ground for objection, of course, is they could always raise a professional complaint against you if they felt minded to do so. So that brings me to the end of the two areas I wanted to cover this morning. And as I say, we'll be carrying on with part 2 of this next month on the 10th of July. So if anybody's got any questions, then please do ask now if you'd like to do so. I'll just have a quick look. I don't see any questions. So with that, I shall carry on to remind you of some dates for your diary. Of course, there is the next coffee break briefing, which is part 2 of this presentation on the 10th of July. And a couple of other dates is that I'm going to be presenting at the SESCA conference at Reading University in September, and also the SESCA seminar at Denby's Wine Estate early in October. So I hope that I may see at least some of you at either or both of those. And with that, I shall say thank you very much. Good to see you this morning, and see you again on the 10th of July, if not sooner. Thank you very much and goodbye.